Good morning. Thank you for joining us for the employment review. Together with April Ranciere, I'm Russell Berger. We're attorneys in the Labor and Employment Group at Offutt Kerman, and today we will be covering hiring and firing employees and, most importantly, minimizing the risk and cost of litigation. Now, I don't know about you, April, but I always like to start my rainy days with a quote from a French philosopher. And obviously the point here, as you can see from the quote on the screen, is that once you're in litigation, you may prevail against the other side, but you're not really going to win. I have a blog up right now on our website talking about this issue and the importance of trying to control risk in employment situations. And in the context of employment issues, that's especially important where there's laws that are employee-friendly and create additional risk to employers. So, one of the main goals of today, and one of the main takeaways for you from today, is to find ways to not eliminate, because that's not possible, but to minimize and mitigate the risk and cost of litigation. So we've got a bunch of goals that all are kind of subsets of the goal I just mentioned. And honestly, this list could probably be another 2 slides long. There's so much to managing the relationship with employees. But what we're really going to try to hit on today are the main issues that create liability for employers in hiring and firing, as well as some of the protections available to employers.
Okay, so first we want to address the hiring and recruitment process that employers should consider having and memorializing. It's important for employers to make sure that any recruitment and hiring process that they have is compliant with the applicable laws. Most employers are aware that employers may not discriminate against employees on the basis of their sex, race, age, national origin, religion, or other protected categories. The same is true for candidates during the recruitment and interview process. A few years ago, the Equal Employment Opportunity Commission, also known as the EEOC, adopted a strategic enforcement plan, and one of the 6 priorities of this plan was eliminating barriers in recruitment and hiring. Since recruitment and hiring is on the EEOC's radar, it is more important than ever for employers to review and update their policies accordingly. Also, as Russell mentioned briefly, these sort of policies, if appropriately tailored to the company, will only protect the company against any sort of litigation or claims later brought against a candidate who wasn't hired or disgruntled employees who are later terminated. Before we talk about the interview process, I want to briefly discuss job advertisements and word-of-mouth recruiting. An employer cannot use a recruitment process that shows a preference for or discourages someone for applying for a job because of protected categories. For example, job advertisements seeking recent college graduates are problematic because it would likely discourage an older candidate who graduated from college many years ago from applying. With respect to word-of-mouth recruitment, an employer who relies on word-of-mouth recruitment by its mostly Hispanic workforce, for example, may also violate the law if the result is that most of the employer's new hires are all Hispanic. Asking candidates to submit photographs should also be avoided because an employer could be accused of refusing to bring a candidate in for an interview because of that candidate's race, age, sex, or other protected category that's visible to the employer through the photograph. In order to avoid problematic recruitment issues, an employer should make an advertisement available to a diverse group of candidates, and the advertisement should outline the job description and requirements and stay away from any other qualifiers, such as recent college graduates, that show preference to a certain category of individuals. Once you have invited candidates in for an interview, you should have an outline of the interview questions beforehand. The key is to always ask questions that are clearly related to the job requirements.
So, April, I actually have a question for you, and I guess we should remind the audience that if you have any questions for us, you can type them in, and they'll pop up on our screen, and we'll be able to see them. But April, the question I have for you is, as you know, my wife's in HR, and she's conducted a lot of interviews over the years. And one time she conducted this interview, and the woman who came in to interview was like 7 or 8 months pregnant, clearly pregnant. As an HR person or the person conducting the interview, should you ask about that?
No.
Comment on it?
You should not ask about an applicant's marital status, pregnancy, or any other perceived or actual disability. The only questions that you can ask during the interview are whether the employee is able to perform the job's duties.
So in my wife's case, she didn't say anything at all, and they ended up hiring the person. And when she came to work, she actually went up to that person and said, "Hey, I'm sorry I couldn't congratulate you or say anything about it during the interview process, but now that you're hired, congratulations, it's very exciting." And she could actually be a normal human being after the interview process was concluded.
Your wife handled that perfectly, because in the event that she had asked or commented on the pregnancy and that candidate hadn't been chosen, that would have opened up the door for a claim that the employer would have had to face. It's important for employers to discern whether an interview can perform the essential job duties. An employer can safely do so without violating the American with Disabilities Act or any other law, as long as the employer asks every single interviewee questions such as, having been told or shown the essential functions of the job, can you perform this job with or without a reasonable accommodation? Every applicant should be asked this question to avoid the perception that an employer is singling out an applicant that is perceived either rightly or wrongly to have a disability. Again, like the example that Russell just described, you shouldn't comment on anything related to a candidate's protected category. Other than a question of this sort of nature that I just described, it is illegal for an employer to inquire as to the candidate's disability. Steer clear of questions related to whether an applicant has filed a complaint with the EEOC, applied for workers' compensation, filed a wage claim, or engaged in other similar protected activities in the past. First, these questions are not related to the essential job duties, and as previously explained, that's what all your questions should be tailored towards. Second, it is illegal for employers to refuse to hire an individual because they engaged in such protected activities.
April, I take it from what you're saying that if you're conducting an interview, you shouldn't just ask the applicant, have you sued anybody, correct?
Correct.
Now, things like court records are all online. So you could, as the employer, the prospective employer, you could probably go online and figure it out. Is that something that, as an employer, you should be doing?
Employers should stay away from conducting that sort of research. Employers do not want to have any sort of information in front of them, like the fact that these candidates may have filed previous claims, because the decision whether to extend a job offer to that candidate cannot be based on that sort of whether or not that candidate had previously filed a claim. So it's just best for the employer to not have any of that information in front of it and to make its decision based on the candidate's qualifications for the job and whether or not they can perform the essential job duties. So as tempting as it may be, you should steer clear of conducting that sort of research. Many times an applicant will list organizations, clubs, and societies that they are involved in outside of work. Some of these organizations may indicate that the applicant is of a particular religion, sexual orientation, or belonging to another protected category. For example, if an applicant's resume states that he's a mentor in the Fellowship of Christian Athletes, an employer should steer clear of asking any questions related to that organization. Again, stick to questions related to the job duties. Okay, I think we have a question we're going to try to answer.
Okay, April, there's a question for you, and the question is, if the job applicant gives you permission to perform a background check, are you allowed to ask questions about the things that show up on that background check?
It depends as to whether or not the things that show up on that background check are related to the job duties. For example, if the job is driving children around or driving anybody, and that background check reveals that that candidate had received a DUI in the past, then because that's related to those essential job duties, that sort of questions related to that DUI may be asked.
And there would be things, too, I think, that would apply to pretty much any job. Certain things about honesty and theft. I mean, those things probably apply to most jobs. So you might be able to ask about those things as well.
Yes, true. Okay. Once the interview process is completed and you have selected the candidate that is best suited to fulfill the job description, an offer letter should be given to that employee. Documentation at the beginning of employment and throughout employment is just as important as documentation of an employee termination. Key provisions of an offer letter include the term of the employment, meaning is this an employment at will or for a specific time period. Most employments are at will, and the offer letter should state that. The letter should also include a brief description of the employee's duties, the employee's compensation, and the law governing the employment. If confidentiality and non-compete provisions are appropriate, such provisions should be included in the offer letter. Generally, these sort of provisions, which are called restrictive covenants, are enforceable if they are reasonably tailored to protect legitimate business interests of the company. A non-compete that precludes an employee from working for any competitor for several years is likely going to be unenforceable because it is not limited in terms of geographic region and time. Finally, always obtain a counter signature on the offer letter and place the fully executed letter in the employee's file. Additionally, in addition to the offer letter, employees must immediately upon hire require an employee to fill out a Form I-9 and verify the supporting identifying documents. Employers must not dictate to potential employees which types of identifying documents should be provided. Instead, employers must provide the potential employee the list of required supporting documentation provided with the I-9 form and allow the employee to produce the documents of their choosing. The Form I-9s should be stored in 3 binders. Binder 1 should be for the current employees, Binder 2 should be for past employees, and Binder 3 for copies of both Binders 1 and 2. During an audit of an employer's Form I-9s, the auditing agent takes Binders 1 and 2. Binder 3 then provides employers with an opportunity to defend against any charges that come up before Binders 1 and 2 are returned. Another key document for employers is a written job description. Updating and revising job descriptions as necessary allows employers to develop appropriate hiring procedures because, as we have discussed, the hiring process should be tailored around the essential job duties for that employee's position. Written job descriptions can also be used during the employee evaluation process. Without a written and distributed job description, an employee who's evaluated poorly can claim that they were not informed of a particular job requirement. This sort of documentation also protects the company against claims of unlawful termination filed by a disgruntled employee.
All right, so moving on our to-do list here this morning is the next topic is preparing for terminations through evaluations and investigations. And so what I'd like you to think about is, imagine you've terminated an employee, and that terminated employee is suing you, making a claim of discrimination. Now, you know the employee was fired for poor performance, but the employee is claiming it was for some other discriminatory reason. How do you defend that claim? Now, obviously, your first instinct might be, well, I know what I did, I'll explain it. And, that's a method of defense, and sometimes that can be viable. But that's a he said, she said type of defense. And the problem with those types of defenses is that, the way the legal process works, you probably have to go all the way to trial to win that case. And that can be expensive and time-consuming and stressful. And so that's not necessarily the most desired method of preparing a defense for these types of cases. So in my mind, the key really is building a factual record, building a record filled with documents that will support your termination decision. And while the burden of proof might be on a terminated employee to prove a discrimination claim, or at least at some stages of the litigation, the real key to a defense is to be able to prove exactly why you did what you did. And one of the ways, or one of the starting points for doing that is the performance evaluation. April, how many times have you seen a performance review that a manager just completed without giving it any real thought?
Too many times to count.
All right, so this kind of thing happens all the time, where it might be evaluated 1 through 5, and it's just a bunch of 3s right down the performance review. That's a terrible way to conduct a performance review, and frankly, it's a waste of your time and your manager's time to conduct performance reviews in that way. Really, the performance evaluation is the measure by which your explanation of this employee was terminated for poor performance will be judged. In every single one of those cases, you're going to go back and you're going to look at performance evaluations in order to determine if this employee was really struggling and having problems and what those problems were. A court or an investigator isn't just going to rely on what you have to say. They're going to go look at the documents and what you actually said over the course of this employee's time with your company. So for that reason, it's important to be accurate and to be detailed in your performance evaluations. And for a similar reason, it's also important to use the performance evaluation to set expectations so that you're setting a goal for the employee knows exactly what they're supposed to do, and if you terminate the employee because they're not living up to your standards, the employee knew what those standards were, and you can show that that was communicated to the employee. Now, as part of this process, you also have to be able to conduct investigations when current or former employees make complaints. Now, at some point, if it hasn't happened to you already, an employee is going to come to you or come to their manager is going to come to you saying, I was harassed, I was discriminated against, I was subject to some other misconduct or inappropriate behavior from a manager. Now, no matter how far-fetched these allegations are, this should set off all sorts of alarms. Now, I have a client who I've represented, and they had a scenario where they took an employee on a company trip, and the employee behaved improperly throughout the entire trip to the point that the company was in the process of deciding whether or not they wanted to terminate this employee. The trip was over a weekend. The employee doesn't show up for work on Monday. They're continuing this conversation. They plan to talk with this employee when the employee comes in. Monday afternoon, from home, the employee sends an email saying, I was harassed, I was subjected to all this deplorable behavior during the course of this company trip over this past weekend. What the company does is it gets all the executives together. They were all on the trip. They were all there and witnesses to all the various allegations that this employee has made. They talk about it. They decide that the employee is just totally making this up. There's no basis to it, and they fire her that night. And what ended up happening is she, of course, filed a complaint, in this case with the state commission, alleging that she was not only harassed and discriminated against, but that she was retaliated against because the company didn't conduct a complete investigation. And of course, we're trying to defend, we're trying to explain that we did conduct an investigation, we didn't need to talk to anybody else, and we didn't need to do any more. But of course, that's not enough for the state. The state's looking for a thorough investigation and looking to see that a process was followed. So as you can see from the slide on the screen now, there is a process. And so, if I could go back in time and advise my client before they made the decision to terminate that employee, this is what I would tell them. You need to follow this process, and you need to conduct a complete investigation. Now, if they had done this, they likely would have been in the clear. because in this particular case, the investigator was really focusing in on the lack of a process. So my client could have gone through this process. They could have, told the employee to stay home for a couple of days with pay while they conduct an investigation. They could have interviewed all the people that were there and gotten statements from all the people that were there. They could have compared those statements to their own firsthand accounting as well as the employee's claims, and they could have reached a decision that could have been laid out clearly in writing and communicated to the employee, and then they could have said, hey, we also need to talk to you about your behavior during this trip, and they could have moved forward on that front. And to kind of give you the counter version of this story, I had a client recently who did pretty much follow this type of process and involved counsel pretty much from the beginning, and to the point where I actually conducted the interviews related to this investigation. And in conducting this interview of the person who was making the complaint, she clearly didn't want to talk to me, and she told me when I asked her, what facts she had to support her claim of being treated differently because of her race, she told me that she didn't know what race was, and she told me that she didn't know what I meant by being treated differently. And those are obviously pretty ridiculous statements for someone who's written an email saying I was treated differently because of my race to make. But the upshot of that was this employee had every opportunity to provide facts to support her claim, and we conducted an investigation and we followed the process, and she didn't give us anything. And she was ultimately terminated. She filed a claim with the EEOC, and the EEOC said, there's not enough here to find probable cause. So I don't know that either of those two employees had a better claim than one another, but I think the way the employers handled it was vastly different. I think that made a big difference in the results for the clients. So in addition to conducting the investigation, part of that process is gathering the relevant personnel documents. So part of what we did in that recent case where the client had a good result was, in addition to conducting the investigation, we helped build the record. So and this happens all the time, and as I'm sure April can attest to, a client will come to us and say, this employee is a problem, we want to get rid of this employee, but we think this employee is just enough of a troublemaker that they might file a claim or they might allege something that would make it problematic for us to terminate this employee. And that happens to you all the time, right, April?
Yes, it does.
Yeah. So part of what we did in this recent example I gave was, through the investigation process, we helped build the factual record. So client had a little bit of email traffic explaining what some of the issues were with the employee's performance, but we were able to build more. And in the back and forth between the employee and the employer, we were able to articulate some of the standards that the employee was falling short of, and we were able to build our case and show the poor performance and build that into the record, so that later on when the EEOC comes in to investigate, the documents are there. There's contemporaneous evidence of poor performance. Now, in building that record, it was important to use a certain type of language. Now, in this most recent example, I ghostwrote the emails. I was involved in crafting that language, and I did it in a way that it would be engineered to appease an EEOC investigator or a judge, someone who's going to be looking at it and making factual decisions based on it. So one of the ways that you do that, aside from hiring a lawyer to do it, is sticking to short and factual statements. And really what you're trying to do when you write a letter or an email or a memo or a report or anything that you're going to stick in the file and you're going to use as evidence is you want to steer clear of opinion, right? Because your opinion doesn't really matter to the EEOC investigator. It's their opinion that matters. But what you want to do is you want to present facts in a simple and accessible way so that the EEOC investigator reaches the right opinion. So one of the things that you often do in this context is you'll write up an employee, or you'll have some sort of letter to the employee, and oftentimes you may want the employee to sign off on that, just like you would with a performance evaluation.
So, Russell, I have a question for you. What if the employee refuses to sign?
I mean, that happens all the time, and probably more often than they actually agree to sign. My answer to that is kind of, so what? I mean, you can't force them to sign, but what you can do is you can make it clear that they were provided the notice. Because from your perspective as the employer, you don't really care if they agree with you or not. I mean, it'd be nice if they did. It would be nice if they just even acknowledged receipt, which sometimes is all you're trying to accomplish by getting them to sign. But really what you're trying to do is to put them on notice and create your record. So if they don't want to accept it, they don't want to sign it, that's okay. Put it in an email and send it to their email. You can show you've sent it to them. FedEx it to their house. Whatever you need to do, just to show that it got there and it was sent and that you put them on notice. Another part of the investigatory process into a claim of discrimination and harassment is conducting witness interviews. Now, obviously, sometimes you're conducting a witness interview of the person making the complaint, and you want to get out their version of facts, and you want to understand exactly what they're complaining. Sometimes, as in my example, the person doesn't want to talk to you. That makes for a short investigation. But usually, the person who's making the complaint is happy to have a forum to vent and get everything out on the table. And as the person conducting the interview, whether it's you at the company or it's outside counsel, there's a couple of important things to try to accomplish, or a couple of important tips. One, I think it's a good idea to have a third person in the room. That helps resolve any factual disputes about what was said, because now you've got two people that are company sponsored or company agents in the room. And to that end, April and I have actually done some of these interviews together. And April, how do you think that process went for you?
It worked out really well. The one example that comes to mind is an employee had complained of sexual harassment, and Russell and I together conducted interviews of the alleged harasser. And having two of us there representing the company or on behalf of the company allows us to obtain all the information that we need during that setting, and also prohibits that particular employee who's being questioned from trying to turn the tables on the investigator and saying that they didn't ask certain questions, or that they are misrepresenting the information that was relayed to the investigator during that particular meeting.
Now, you're also going to be able to conduct interviews of third parties, other witnesses besides the person making the complaint and the person being alleged of the misconduct. And while this applies to all witnesses, this is probably especially true of third parties that, in theory, could be witnesses for either side. If you can commit a witness like that to writing and get them to sign off on it, it's very beneficial to your efforts as the employer. Because it makes it easier to tell your story to an investigator, because you've got something signed by a third-party witness, and it also locks that third-party witness into their testimony. So you've got something out on the table, and it's now locked in. One other note with respect to conducting the investigation is you have to be careful about how you use your managers. Now, April and I have both conducted management training, and lots of times we find that managers become managers not because they're inherently good at managing other people, but because they were the best person at whatever the job was. So if you're the best salesperson, you might become a sales manager. If you're the best marketing person, you might become the head of marketing for a company. And while your substantive skills might be great, you don't necessarily have any training at managing other people or conducting these investigations or how to handle things when employees come to you. So, it's important to remember that well-meaning managers can derail the process or create bumps in the road. So it's important to make sure that your managers are trained as well so that they don't get involved and create a problem. Now, lastly, as part of the investigatory process, I want to make a note about handbooks. Now, April's about to hop back on the mic and discuss handbooks in a little bit more detail, but I do want to point out that the handbook sets forth the basic rules of behavior at your company. And the handbook should be broad enough to generally cover most issues, but it should also give you some wiggle room and some discretion. But with respect to the investigatory process, you want to make sure that what you're doing is in line with your handbook. And because the handbook sets forth kind of these basic rules, and hopefully you've got a handbook that sets forth the basic rules accurately and in a way that gives you some flexibility in applying them, you always want to make sure you're acting within the framework of your handbook, because once you start going outside the scope of your handbook, you leave yourself open and vulnerable to a claim that you're treating this employee differently, which is the hallmark of a discrimination claim.
Okay, so moving on to specific employee handbook provisions that can be used by employers as yet another tool to protect itself when subjected to a claim of wrongful termination. Employee handbooks, while essential, must also be regularly updated to ensure that they are compliant with applicable laws. This has been especially important during the last few years as the National Labor Relations Board, also known as the NLRB, has recently begun to scrutinize employee handbooks and penalize employers whose handbooks are deemed unlawful. All employees should receive a copy of the handbook and sign a written acknowledgement of receipt, which the employer should place in the personnel file. This is, again, another important piece of documentation that can be used to paper the file in the event that the employee later complains that they weren't aware of a certain company rule or unsure of how to complain about sexual harassment or some other form of discrimination. We have listed on this slide certain essential company rules that we recommend be included in the employee handbook, and I'm going to highlight a few. The first, internet personal email usage. These sort of policies, along with social media policies, are a hot button topic for the NLRB, and if your policy has not been updated in the past year or so, it should be reviewed with the NLRB's recent findings in mind. For example, the NLRB recently determined that an internet rule that prohibited employees from using a company's logo, trademark, or graphics without prior written approval from the company was improper. The NLRB found that this provision could be reasonably interpreted as prohibiting online protected communications. So most of the time when I'm reviewing handbooks, which Russell and I do all the time, and updating them for companies, I see that the internet and social media policies are way too broad and are not appropriately tailored with these recent NLRB findings in mind. And that's something that is essential for companies to do, because if you have a handbook that is not compliant with these recent rules, you're not only opening yourself up to penalties, but your handbook may be deemed unenforceable for some of the other rules that you have that you're trying to bind the employees to. Anti-harassment and anti-discrimination policies are also essential and must be included in the handbook. These sort of policies, like Russell talked about previously, protect an employer against a claim of discrimination, harassment, or unlawful termination. The policy should detail the complaint and investigation process so that an employee cannot later claim that they had no one to report the alleged harassment to. In the event that an employee does complain of harassment or similar conduct, the employer should follow the investigation policy outlined in the handbook. If you do have a complaint of harassment or discrimination and it's determined that the investigation policy that's included in the handbook is not necessarily working for your company, then that policy should be updated and redistributed to the employees. Workplace conduct should also be included in the handbook. This sort of provision is important for all companies and can be especially important for restaurants in regulating undesirable conduct. For example, in restaurants, if your bartenders are not permitted to accept drinks that are bought by customers while they're working, this should be included in the employee handbook. Are employees allowed to drink at the bar after their shift when they're no longer on duty? If not, this is the sort of thing that should be included in the employee handbook. Additionally, and this is not listed on the slide, but policies related to tip pooling, tip credits, and timekeeping policies should be included in the handbook. And as for all companies, regardless of whether or not it's a restaurant, policies related to timekeeping and the payment of wages should be included in the handbook so that the employees understand exactly what is expected of them.
With respect to the tip pooling and the tip credit being in the handbook, would you get into a lot of detail in the handbook? Because obviously there's going to be a tip pooling agreement that's signed by the employee as well, so how would you handle that in a handbook?
Well, I would outline the process and how it works so that way the employees know exactly how the tip pooling procedure will take place. And having it documented twice is never a bad thing. So regardless of whether or not you have a policy that the employees have signed, the handbook is another documentation that can give the employees the notices that are required by the FLSA for proper tip pooling and tip credit. Employers can also include provisions which will dictate how claims brought by employees will be handled. For example, an employer who's exclusively located in Maryland may want to include a choice of venue that dictates that any claims may be brought in Maryland court. This is true for employers who have several offices in different states. They may want to dictate the venue that's most convenient for that employer. We have talked about retaliation claims and how to protect employers from those sort of claims. Certain risk factors exist that expose employers to retaliation claims. Retaliation claims are presently the most common type of claims filed with the EEOC. Retaliation is defined as any adverse action taken against an employee for filing a complaint or supporting another employee's complaint. Examples of adverse action include demotion, suspension, negative performance evaluation, and termination. Retaliation claims can be brought by an employee even if the underlying complaint was focused on conduct that is not illegal. This is true as long as the employee complaining brought that complaint based on a reasonable, good faith belief that the complainant practice violates anti-discrimination laws. So, any employee complaint, regardless of whether or not the conduct complained of is illegal, should be investigated by the company pursuant its anti-harassment and discrimination policies. Risk factors that expose companies to retaliation claims include lack of documentation, lack of written policies and procedures related to anti-discrimination, anti-harassment, and the complaint process, not investigating complaints or not investigating complaints promptly or fully, and making knee-jerk decisions instead of reviewing the employee file and determining what other risk factors may exist prior to terminating or taking any other adverse action against the employee. So in order to avoid retaliation claims or reduce exposure if a claim is made, if we haven't made it clear already, the most important thing to do is to document, document, document. That is the most important thing that an employer can do to protect itself. Timing is also important. Russell described the case that he had dealt with where the employer terminated someone right after they complained. While they had a good basis for terminating that employee, the timing alone causes a great deal of suspicion that the company is now having to deal with in terms of the retaliation claim that's been brought against it. So you want to, before you take any sort of adverse action, especially termination, you want to review the employee's file, determine what, if any, risk factors exist. Has the employee complained before? Did the employee recently notify the company of a disability or pregnancy? All of these sort of determinations must be, or factors must be considered before making a termination decision.
All right, so one of the inevitabilities of being an employer is that you're going to have to terminate employees at some point. There's my guy, Arnold, the Terminator. Hopefully you're a little bit more gentle than the Terminator would be. But, you know, spoiler alert, the termination process really should begin with good documents and good records. So just like the question I asked at the beginning of this presentation, when you decide you want to move forward with the termination, you should be asking yourself, is there enough evidence to justify the termination decision? Now, obviously, as we've talked about at length, that really begins with proper documentation and, you know, can you build your case on paper alone? Another aspect of it is once you kind of lay out your case for why you're terminating the employee, you know, it makes sense to conduct an objective review of that decision. Now, sometimes that might be an HR director, sometimes that might be outside counsel, sometimes it might be, you know, a fellow manager. But it makes sense to get someone who's not involved personally, doesn't have any emotion invested in the outcome, to look at it and say, okay, well, you know, here's what I think the risk is. Here's what I think would make this a more defensible termination decision. Here's why I think you're asking to get sued if you do this. Now, once you decide to go ahead and move forward with termination, you're going to have to meet with the employee. Now, I think in doing so, it's important to remember that even if you don't particularly like the employee you're terminating, and you might be happy to see that person go, that terminated employee is still a person that should be treated with honesty and respect. And, you know, while, like I said, you might be happy to see that person go, you're going to be a lot happier if that person stays out of your hair moving forward. And I think one of the ways to increase your chances of that being the case is to show a little dignity to the person. And when you're explaining the termination decision, you do so you know, in a manner that's short, sweet, and to the point. You know, part of the job of making the termination or attending the termination meeting is to be prepared. And part of the way you prepare is by reviewing the documents, understanding your reasons, and being able to articulate your reasons clearly and succinctly. And once you get into the meeting, you're not into a debate. This isn't a back and forth, right? The decision has already been made, so you lay it out and you explain why the decision is or what the decision is, and you explain here's what's going to happen administratively with respect to pay, keys, computers, equipment, anything like that. And you might also explain, you know, here's what we're going to do with respect to you know, people calling for references if you're looking for other employment, and, you know, here's what you need. You know, we'll get you COBRA notice or those sorts of things. Now, one of the other things that you have to be mindful of when you're terminating an employee is the rules applicable to final pay in the state of Maryland. Generally, what you have to do is you have to pay the employee for the time that they worked up until you know, the time that they've been terminated, and you have to make that payment by the normal pay date. So you pay them out like you normally would. Now, one of the wrinkles under Maryland law is that if the employee has accrued but unused paid time off, you have to pay that as well. Now, however, there's a way around that. Now, if you have a policy that's in place that says we don't pay out accrued unused PTO and employees have received notice of that policy, you don't have to pay it out. So there's no real hoops you have to jump through to avoid having to pay that out. You just have to make employees aware of that policy, and you have to have it in writing. But if you don't have that policy, you're going to have to pay out accrued and unused PTO at the time of termination. And now it's also important to make sure you get this right, because under Maryland law, if you make a mistake in this front, you can be subject to what's called treble damages. April, do you know why they use the word treble instead of triple?
I do not.
I don't know either. I always find it weird, but because it basically means the same thing. So, for example, if you owed someone the equivalent of $500 in accrued and unused PTO, if you didn't pay it out, they could sue you for $1,500 and their attorney's fees. So it's important to get that right. Now, it looks like we have a question. April, maybe you can help me out with this one. An at-will company, or dealing with an employed at will, should you give that person a reason when you're terminating them?
Yes.
Yeah, I would agree with that. And the reason I would do it is because if you don't give them a reason, it's just a question mark that's hanging out there, and the employee could think, it is for a discriminatory reason. Sometimes you can be general and somewhat vague in your answer, or you could say, we're terminating you because of general poor workplace performance or trouble getting along with other employees. And you don't necessarily have to go through every example that exists of that general problem in the workplace, but I think it's important to point to something. Because as you know, with an at-will employee, they can be fired for any reason or no reason, as long as it's not discriminatory or otherwise against the law. But I do think it makes sense to give a reason. And if you can't explain a reason in a sentence or two, you have to rethink your whole decision to terminate that employee, because you're going to have a hard time defending if that employee makes a claim of harassment or discrimination or some other wrongful conduct. One other consideration when terminating an employee is what to do about references. My preference generally is for neutral references. So one of the things that can happen is, a potential employer of someone you've terminated gives you a call and asks about the employee you just terminated. And you probably have a lot you want to get off your chest, and you're ready to unload about this problem employee to their new hire. That's not always a great idea, because that can get you in trouble, depending on how far you go. And it can also, frankly, be against your interest if the person's collecting unemployment or making some sort of claim for lost wages against you. You might actually want the employee to find a new job. So generally what I recommend are neutral references, which are dates of employment, confirming salary history, things like that, but without getting into an evaluation of the employee as a person or as an employee. Now, one last tip related to terminations has to do with exit interviews. When you terminate an employee, they're probably a lot more likely to be honest about what they think of the company, where there's room for improvement, what they think of their supervisor, than when they're an ongoing employee subject to all the rules and the pressures of being an employee. So conducting exit interviews can be a great way to learn about certain managers and to improve your practices and processes.
Okay, so one of the things that you may have to deal with, or you will have to deal with even after an employee is terminated, is unemployment claims. As depicted by these numbers on this slide, all employers will deal with unemployment claims. In March 2016, there were 8 million unemployed persons in the United States, and the number of long-term unemployed, meaning those who were jobless for 27 weeks or more, was 2.2 million. Dealing with unemployment claims can be time-consuming and extremely frustrating. There's just a few simple guidelines that employers can follow in order to streamline this process and make it a little bit easier to deal with. First, communicate the reason for terminating the employee in writing. We answered that question a few minutes ago as to whether or not an at-will employee should be given a reason for their termination. It's important for many reasons, and defending against unemployment claims is one of those reasons. Employers should challenge unemployment awards when the employee either voluntarily resigned or was terminated for misconduct or gross misconduct. Misconduct is usually not bad performance and is generally defined as numerous and egregious violations of written rules after ample warning. Things such as stealing or fraud would most likely be deemed as misconduct for the purposes of unemployment claims. In addition to the documentation that we've talked about and the policies and procedures that employers can follow to defend itself against claims brought by disgruntled employees, there are certain procedural protections that employers can utilize to best position itself in defending a claim brought by an employee. The first is jury trial waivers. Juries in certain jurisdictions tend to be pro-employee, and in those sort of jurisdictions, an employer could consider including a jury trial waiver in the handbook or have the employee sign a separate agreement acknowledging that they're aware of the jury trial waiver. For any claims to which a jury trial waiver is subject to, all issues of that claim will be decided by a judge. That judge will be more familiar with the law than juries and will hopefully be able to make a determination from a less emotional standpoint than a jury would and apply the law and recognizing all the actions that the employer hopefully took in terminating that employee in the proper manner. Another procedural protection that an employer could consider is mediation clauses. Mediation clauses force meaningful conversation prior to the institution of arbitration or lawsuit. It requires the parties to mediate the issue before a mediator. That mediator will have no authority to decide the issues or bind the parties. Mediation can be used as a valuable way to discover information. You will usually learn all about the employee's claims or things that they believe that they were wronged by during the mediation. Another positive aspect of mediation is that predetermined costs are known up front by the parties, and in order for it to be effective, the parties need to have resolution in mind prior to the mediation. Another procedural protection are arbitration clauses. These are quite popular for employers to include in their employment agreements or handbooks. Arbitration clauses are binding on both parties. An advantage of arbitration is that it can at times be less expensive than a typical lawsuit brought in court. It's usually much faster than the court process. A disadvantage of arbitration is that you're relying on an arbitrator who may not be a judge and who may not be that familiar with the area of law. Here we would be talking about employment law that would be the subject to the claim. And probably the biggest disadvantage of arbitration is that there's very, very limited appeal rights. So you're basically stuck with the decision that you get. If the arbitrator makes a decision that's not grounded in law, you're going to have a really hard time appealing that decision. Whereas if you're in court, you would have those appeal rights. Whether or not to include one of these procedural protections is really factually driven and should be made based on the employer's specific needs. There are times where Russell and I will recommend that an employer include an arbitration clause, and then for a different kind of company, we will recommend that they don't include any of these procedural protections that we just discussed. So it's just something that needs to be evaluated on a company-by-company basis.
All right, so we've wound our way through the employee's life cycle, and you're at the stage where you're terminating the employee, and you want to consider whether or not to use a severance agreement. Now, severance agreements are a way for employers to essentially buy their peace. Now, I don't think April nor I have any problem with our clients being principled, but sometimes principles are expensive. And sometimes it makes more sense to just buy your peace, cut your losses with a particular employee, and move on. So one of the other things that happens from time to time is we'll find out that one of our clients paid an employee a few weeks of pay at termination just as essentially a going away present. And they didn't go forward and actually obtain a release or a severance agreement. Those employees sometimes will come back and sue you, and the employer will say, "Man, I paid them 2 weeks' pay when they left. Don't I have a release? Can I get can I get that back?" And the answer is always no. So if you're willing to do that, or if you're willing to buy your peace, there's some things you definitely ought to have. Obviously, you need a release, because that's really what you're buying, is you're not going to sue me. That's what the release is. With respect to the FLSA, which is the overtime law that you see people advertising for on television all the time now, that particular law, at least the federal version of it, can't be released without a court approval or the approval of the Department of Labor. So you can't really release that claim, but what you can do in a severance agreement is you can get a statement saying, "I've been fully compensated for all hours worked." You can include language to that effect, and while it doesn't eliminate entirely the possibility of that claim, it does give you a piece of evidence that you can use. And then there's some other laws. The age discrimination law requires certain language to be included in the release, so you want to make sure you have those magic words. Lastly, there's some other things that are not critical, although in some cases they may be. But you might want to also consider a non-disclosure or as well as a non-disparagement, so that way the employee can't go out and say, "Hey, I got all this money from the company," or what horrible people they are. You should never work for them, or you shouldn't do business with them. Sometimes it can be very important to have those provisions included, as well as restrictive covenants. Now, with respect to restrictive covenants, you might already have them in place, things like non-competes, non-solicitations, and anti-employee rating provisions. But you might want to reiterate them at the time of a severance, or in the event that you don't already have them, but you decide you want them, you can stick them into a severance agreement, and since you're paying a consideration as part of the severance agreement, those would still be enforceable. So if you have any questions, feel free to shoot them into us. I know we've got one in the queue already. The question is, what do you do if someone asks the questions, and I assume this is in the context of someone seeking a reference, is this employee eligible for rehire? And again, just like everything else, it's ultimately up to you as the employer how you want to handle that, as long as you handle it consistently. Now, I think my advice on that would be to steer clear of it entirely, and not answer yes or no. Just say that's not something that we answer, because I think you open the door a little bit by even getting into that. All right, so looks like we're getting few more questions here. We're almost out of time. All right. April, I think there's a question coming in here regarding arbitration clauses, and I can probably add to it a little bit since I've dealt with these. You were talking earlier about how sometimes arbitration clauses make sense and sometimes they don't. What type of scenario generally would make sense for an arbitration clause?
Sure. Anytime a company could potentially be subject to a class action or a action brought under the Fair Labor Standards Act, if you have many employees employed in similar types of jobs or paid in similar ways, or your company is in an industry that is frequently subjected to class actions, then I would certainly recommend arbitration clauses and class waivers for those sorts of employers.
Yeah, I tend to agree with you. I'm not a big fan of arbitration because one of the downsides to it is that generally the law is set up in such a way that the employer has to pay for the whole thing. So to me, the real value of an arbitration clause for an employer is to avoid class actions. Well, it looks like that's all the time we have for today. I believe these slides are going to be made available to you or going to be emailed out to you. Also, I believe that this presentation has been recorded and it's going to be posted on the Offutt Kerman YouTube channel. And it should also be sent out, maybe a link to that with the slides. If you can't tell, I'm not the most savvy tech person in this room, so I think all that stuff should be made available to you. And if you have any questions or other follow-up or want more information, you can always feel free to email April and I or give us a call. Thank you for your time this morning.
Have a good day. Thanks for joining us.